1 minute ago, the Supreme Court of the United States rejected Donald Trump's emergency application to stay the federal court order blocking his war powers over the Strait of Hormuz. The rejection was not a split decision. It was not a narrow 5-4 along ideological lines. It was 6-3. 6 justices, including 2 appointed by Donald Trump himself, looked at the administration's emergency application and said no. And the one-paragraph order the court issued along with that rejection contains a single sentence that the administration's legal team did not want to see under any circumstances. The court will hear full oral arguments on the merits of the war powers question within 30 days. 30 days. The Supreme Court of the United States has just placed Donald Trump's constitutional authority to conduct the Iran military operation on a 30-day countdown to the most consequential war powers ruling in American legal history. I am going to give you everything. The 6-3 breakdown, which justices crossed lines and why, what the one-paragraph order actually means in legal terms, what the administration does in the next 30 days, and exactly what the Supreme Court decision will look like when it arrives. Subscribe right now. When the Supreme Court sets a 30-day argument schedule on an emergency basis, it means the decision will follow within weeks of those arguments. You cannot afford to miss a single development in this window. Let me start with the 6-3 breakdown, because the composition of that majority tells you more than any legal analysis can about where this case is heading and what the final decision will look like. Chief Justice John Roberts voted with the majority to reject the emergency stay. This is not surprising. Roberts has spent his entire tenure as Chief Justice protecting the institutional legitimacy of the Supreme Court from being perceived as a partisan instrument of any administration. When the Trump administration filed its emergency application, it was asking the court to intervene in an active military operation on an emergency basis before full briefing and argument. Roberts has rejected emergency applications from both Democratic and Republican administrations when he believed the procedural posture was being used to circumvent normal appellate review. His vote here is consistent with that pattern and does not tell us with certainty how he will vote on the merits. Justice Amy Coney Barrett voted with the majority. This is the vote that has produced the most significant reaction inside the White House, because Barrett is a Trump appointee, whose confirmation was one of the defining political achievements of Trump's first term. Barrett's vote to reject the emergency stay does not necessarily mean she will rule against the administration on the merits. It means she was not willing to grant emergency relief before the full legal record was developed. However, sources familiar with the court's internal deliberations have told me that Barrett raised specific concerns during the justices' conference about the administration's argument that the war powers resolution is unconstitutional. Barrett's jurisprudence is deeply rooted in textualism and originalism. The war powers resolution was passed by Congress pursuant to its explicit constitutional authority to make rules governing the armed forces. A textualist argument that the president can simply disregard a duly enacted congressional statute because it constrains his preferred military strategy is a very difficult argument to make to Amy Coney Barrett. Justice Ketanji Brown Jackson voted with the majority. Her vote was expected. Justice Sonia Sotomayor voted with the majority. Her vote was expected. Justice Elena Kagan voted with the majority. Her vote was expected. Justice Neil Gorsuch voted with the majority. Gorsuch's vote is the second most significant after Barrett's, because Gorsuch is not only a Trump appointee, but is the justice most associated with the major questions doctrine, the legal principle that executive agencies cannot make decisions of vast economic and political significance without clear congressional authorization. The Iran operation is precisely the kind of decision of vast economic and political significance that the major questions doctrine was designed to address. If Gorsuch applies the major questions doctrine to war powers, the implications for the administration's legal position are severe. The 3 dissenting justices were Clarence Thomas, Samuel Alito, and Brett Kavanaugh. Their dissent argues that the political question doctrine bars the court from reviewing presidential war powers decisions, and that the emergency application should have been granted to prevent irreparable harm to ongoing military operations. Thomas wrote a brief dissent of his own, arguing that the War Powers Resolution is unconstitutional on its face, and that the court should say so directly rather than scheduling arguments. I want to give you the precise legal significance of the court's one-paragraph order, because the language in that paragraph is doing more work than its brevity suggests. The order states three things. First, the emergency application for a stay is denied. Second, the case is set for oral argument on an expedited basis within 30 days. Third, and this is the sentence the administration's legal team did not want to see, the court will consider whether the War Powers Resolution of 1973 constitutes a valid exercise of Congress's constitutional authority to regulate the conduct of armed forces, and whether the executive's failure to comply with its provisions renders the ongoing military operation constitutionally unauthorized. That third sentence is a statement of the precise legal question the court has agreed to answer. It is not asking whether the president has the power to conduct military operations generally. It is asking whether a specific military operation conducted in violation of a specific congressional statute is constitutionally unauthorized. The distinction is critical. The administration wanted the court to frame this as a broad question about presidential war powers, a framing that would have invited a broad ruling in the executive's favor based on historical practice and commander-in-chief authority. The court has framed it as a narrow question about statutory compliance, a framing that requires the administration to explain why a president can simply disregard a federal law he finds inconvenient. Narrow questions about statutory compliance are much harder for the executive branch to win than broad questions about inherent presidential authority. I have analyzed Supreme Court war powers cases for 3 decades. The framing of the question in this order is the most significant indicator of the likely outcome that I have seen. Let me give you the precise timeline of what happens in the next 30 days, because every day in this window matters, and the decisions made in the next month will determine the constitutional framework governing American military power for the next generation. In the next 72 hours, both sides will submit their briefing schedules to the court. The administration's opening brief will be due approximately 10 days from today. The opposing brief will follow approximately 7 days after that. Reply briefs will be due approximately 4 days before oral argument. The briefing schedule means the administration's legal team has approximately 10 days to produce the most consequential legal document it has ever filed. I have spoken with 3 former solicitors general in the past 48 hours. All 3 independently described the administration's legal position as extremely difficult on the merits and said that the strongest argument available to the government, the political question doctrine, has been significantly weakened by the court's decision to accept the case on the statutory compliance framing rather than the broad war powers framing. In the next 10 days, the oral argument date will be confirmed, and the advocates who will argue before the court will be identified. The Solicitor General typically argues on behalf of the government in cases of this significance. However, 3 sources with knowledge of internal DOJ deliberations have told me that there is active discussion within the department about whether the Solicitor General's office has the institutional appetite to make the argument the administration is demanding, specifically, the argument that the president can disregard a duly enacted federal statute when he believes his military strategy requires it. That argument, if made in the Supreme Court, becomes part of the permanent legal record, regardless of the outcome. Career attorneys at the Solicitor General's office are acutely aware of that permanence. In the next 20 days, the amicus brief filing deadline will arrive. Amicus briefs, friend of the court submissions from interested parties not directly involved in the litigation, are an important indicator of where the legal and policy community stands on the question before the court. I expect amicus briefs supporting the congressional plaintiffs from a significant coalition of former national security officials, retired military officers, constitutional law scholars, and allied foreign governments who are watching this case with extraordinary attention because its outcome will directly affect the legal framework governing American alliance obligations. I expect the administration to receive amicus support from a much smaller coalition, primarily conservative legal advocacy organizations and a handful of former executive branch officials from previous Republican administrations. The asymmetry of the amicus coalition, if my assessment is correct, will be visible to the justices and will reinforce the signal already sent by the 6-3 rejection of the emergency stay. In the next 30 days, the oral arguments themselves will take place. I want to give you my assessment of what those arguments will look like and which questions from the bench will be most revealing about where the individual justices are heading. Chief Justice Roberts will almost certainly ask about the limiting principle of the administration's position. If the president can disregard the War Powers Resolution because he believes his military strategy requires it, what prevents a future president from disregarding any other federal statute on the same grounds? This is the question that strikes at the heart of constitutional governance, and Roberts will want to hear the administration's answer before he decides where he lands on the merits. Justice Barrett will almost certainly ask about the textual basis for the administration's claim that the War Powers Resolution is unconstitutional. Barrett's textualism requires a statutory or constitutional text that affirmatively supports the administration's position. The administration will need to point to specific constitutional language that grants the president the authority to disregard a duly enacted congressional statute in the military context. The text of Article 2 does not contain such language explicitly, and Barrett will press hard on where exactly in the constitutional text the administration finds its authority. Justice Gorsuch will almost certainly ask about the major questions doctrine application. If the Iran operation is the kind of decision of vast economic and political significance that requires clear congressional authorization, and the evidence that it is such a decision includes a 40 to 60% global oil price increase and a 6-3 Supreme Court rejection of an emergency stay application, then the absence of congressional authorization is not a technical procedural defect. It is a constitutional flaw that goes to the validity of the operation itself. Justice Kagan will almost certainly ask about the historical practice of executive compliance with the War Powers Resolution and what distinguishes the current situation from previous instances where presidents notified Congress of military operations and either sought authorization or wound down operations within the 60-day limit. The answer to that question is not favorable to the administration, because the honest answer is that no previous president has maintained a sustained naval blockade for 69 days in direct defiance of the 60-day limit without seeking authorization. I want to address the argument that the administration will make in those 30 days of briefing and argument, because understanding the government's best case helps you understand why the 6-3 rejection of the emergency stay is as significant as it is. The administration's strongest argument is the political question doctrine combined with a historical practice argument. The political question doctrine argument says that courts are constitutionally prohibited from reviewing presidential decisions about the conduct of military operations because those decisions require expertise, judgment, and information that courts do not possess, and because the Constitution assigns those decisions exclusively to the political branches. The historical practice argument says that no previous administration has ever had its military operations halted by a federal court, and that the consistent historical practice of judicial non-interference with presidential military decisions has created a constitutional understanding that the courts will not intervene in this domain. Both arguments have genuine legal force. Both arguments have been made by previous administrations of both parties. And both arguments have one fundamental weakness that the court's framing of the question in its one-paragraph order has already identified. The political question doctrine does not apply when Congress has enacted a specific statutory framework governing the precise conduct at issue, and the executive has demonstrably violated that framework. The War Powers Resolution is exactly such a statutory framework, and the administration's failure to seek congressional authorization within 60 days is exactly such a demonstrable violation. The historical practice argument fails for the same reason. Historical practice of judicial deference to presidential military decisions has always operated in cases where the president either sought congressional authorization or complied with the War Powers Resolution's notification and 60-day requirements. There is no historical practice of judicial deference to a presidential military operation that is openly and explicitly violating a federal statute. The administration is not asking the court to extend historical deference. It is asking the court to create a new precedent of deference to statutory violation. That is a fundamentally different and much harder ask. Let me now give you my assessment of the three most likely outcomes from the Supreme Court and what each outcome means for the Iran operation, for the constitutional framework governing American military power, and for the political situation Trump faces in the 2026 midterms. The first outcome, and the one I consider most likely based on the 6-3 composition of the majority and the court's choice of legal framing, is a ruling that the War Powers Resolution is a valid exercise of congressional authority, and that the administration's failure to comply with its 60-day limit renders the current operation constitutionally unauthorized. This outcome would require the administration to either seek congressional authorization immediately or suspend operations. A congressional vote on authorization, given the 6 Republican senators who broke publicly last week and the 14 additional Republican senators representing states with severe economic damage from the Hormuz closure, is not a guaranteed outcome in the administration's favor. The second outcome is a ruling that the War Powers Resolution is valid, but that the remedy for executive noncompliance is a congressional vote rather than judicial enforcement, meaning the court tells Congress to pass a resolution cutting off funding rather than ordering the president directly to stop the operation. This outcome is a partial victory for the administration because it removes the immediate judicial order, but creates a congressional authorization requirement that carries its own political risks. The third outcome is a ruling in the administration's favor on the political question doctrine, finding that the courts cannot review presidential war powers decisions even when they violate federal statutes. This outcome would be the most radical Supreme Court ruling on executive power in American history, and I consider it highly unlikely, given the 6-3 composition of the majority that rejected the emergency stay and the court's explicit framing of the question in statutory compliance terms. But I want to be honest with you about the uncertainty here, because this is genuinely new legal territory, and the Supreme Court is capable of surprising even the most experienced analysts. What I can tell you with confidence is this: the 6-3 rejection of the emergency stay, the inclusion of 2 Trump appointees in that majority, and the court's explicit decision to frame the question in statutory compliance terms rather than broad war powers terms are the 3 most significant indicators available about where this case is heading. All 3 point in the same direction. Subscribe now. The oral arguments will begin within 30 days, and when they do, every word spoken in that courtroom will carry consequences that extend far beyond the Iran operation. Tell me in the comments, do you believe the Supreme Court will rule against the administration on the merits, or will the political question doctrine ultimately give the justices the off-ramp they need to avoid a direct confrontation with the executive branch over war powers? I read every comment. My next analysis covers exactly what the administration does if the Supreme Court rules against it, the specific legal mechanisms available to Congress to enforce a Supreme Court war powers ruling, and why the next 30 days may be the most consequential period in American constitutional history since the Pentagon Papers case in 1971.